Okay, we have somebody joining us on the phone with the last four digits of 7758. Can you tell me your name, please?
Ken Kashoniak.
Kenneth Kashoniak. Okay, thank you. All right, Ms. Krause, are you able to hear me okay?
I can.
Okay, great. So we'll go on the record in Brown versus Kashoniak, case number 1314961. Record should reflect Mr. Kashoniak is present today by phone through Zoom. We have Ms. Krause here on behalf of friend of the court. This is set for a hearing on a show cause for failure to pay child support. Ms. Krause, how does the friend of the court want to proceed on this case today?
We would be asking for the bond to be released to friend of the court. A bench warrant was issued on June 3rd for the defendants failed to appear for a show cause. The defendant posted bond in the Otsego County with the Otsego County Sheriff's Department in the amount of $1,085. The defendant has a support obligation of $291 and a balance of $4,327.70. Once the bond posts, that balance would be $3,242. The last payment was received in April in the amount of $100.
Okay, so if the court orders the bond to be released, then would you set this for another hearing to monitor, or what would be the next step?
We would ask that the defendant pay $600 by the end of the month, and then the friend of the court would forego contempt proceedings. Otherwise, the friend of the court would be seeking contempt pursuant to the May 1st recommendation made by referee legal.
Okay, thank you. Mr. Kashoniak, were you able to hear all of that?
Yes.
Is there anything you wanted to say regarding the friend of the court's request of the court today?
Not at this time.
Okay. Are you going to be able to make that payment as indicated?
Yes.
Okay. All right. So the court will order that the bond that was posted be posted to the account against the arrearages, and then the court will adopt the recommendation of friend of the court in terms of the additional payment. And is there anything else we need to address on this file, Ms. Krause?
No.
Mr. Kashoniak, do you have any questions at all?
No, sir.
Okay, thank you. You're free to disconnect at this time.
Thank you.
All right, sir, are you Tyler Hassel?
Yes, Your Honor.
Okay. All right, we're on the record now in Bergman versus Hassel. Okay, again, we're on the record in Bergman versus, or Hassel versus Bergman. Technically, given the caption of the case, this is file number 1716873. The record should reflect Mr. Hassel's present today by video from Otsego County Jail. Mr. Hassel was arrested on a bench warrant for failure to pay child support. Mr. Hassel, do you understand why you're before the court today?
I guess I'm still trying to figure out. I was making payments consecutively for over a month, $300. I had a good job for almost 4 months. You guys issued a warrant even after I was making payments. You took over $1,200 and still issued a bench warrant after receiving payments. And then I still had the job for 3 months after you issued the bench, or 2 months after you issued the bench warrant, and you guys were taking so much money out of my check. There was only $174 left for me and my children to live on, and my 1-year-old. And I ended up losing my job because there wasn't enough money for gas to get left after insurance and everything else. I was making payments, and I'm not sure why I had a warrant issued, other than I never got a paper about a court date. I'm not quite sure why we are at this point when I was making consecutive payments. I paid almost $4,000 over a little over a month ago. I made efforts. I have a 1-year-old baby. I have a family, and I'm still paying well over what I make.
Okay, Ms. Kraus, can you tell me what the status is, or how the friend of the court wants to proceed today?
Yep. On April 18th, a bench warrant was issued with the bond amount of $5,300 after the defendant failed to appear before a referee on April 17th. A notice of the hearing was mailed to the defendant's last known address on March 7th, and the defendant was given verbal notice of the hearing on April 11th. The defendant has a support obligation of $883 and a arrearage balance of $19,821.06. Friend of the court received information that the defendant was employed since February 26th. However, he did not report this employer, and the employment information was obtained from National New Hire. Friend of the court was able to put an income withholding in place and payments of $1,258.25 and $1,121.65 were received in May and April. However, no payments have been received since May 29th. The friend of the court is seeking to have the defendant found in contempt for his failure to appear on April 17th and for failing to pay his child support obligation out of available resources.
Okay, Mr. Hassel, is there a reason why you didn't appear for that hearing in April?
Yes, Your Honor. By the time I was working night shift at Cooper Standards here in town, it was a good job. And I was the entire time I worked there. For over 2 months, they were taking $300 a week, every week out of my check. I have the receipts for it all. They took well over almost $4,000 the entire time I worked there from me out of my check. And then I worked night shift. I got out and I ended up sleeping through my alarm. I apologize. And it was a big adjustment for me. I haven't worked night shift in years. I have a 1-year-old baby. I have 2 stepdaughters that I take care of, and my spouse, and I apologize. And all I can say is I have $800 that I can give you guys right now. Me being in here is doing no good for my children, and it's not getting you guys any money. But as of right now, I have $800 that I can give towards a balance.
All right, are you currently employed?
I lost my job at Cooper Standard because my checks after garnishments, and I was being garnished for another debt. And then I was also paying for insurance, Blue Cross Blue Shield, out of it, out of my check, $100 and something a week. And I only made $800 a week. So after taxes and everything, I was getting $160 something to live on average. And some weeks I would get overtime, so they would hit me even harder. And I ended up losing my job because I drive a V8 truck and I couldn't afford to drive 40 minutes each way. And I was living on $170 a week and spending $100 of it on fuel. And I ended up losing the job because I couldn't afford to get back and forth. They were taking so much money out of my checks.
Okay, here's how we're going to proceed on this file today. First of all, the court's going to set this for a contempt hearing in August. The court is going to modify the bond in this case to $500. So, Mr. Hassel, you need to post that $500 bond to be released. The court's going to order that once that bond is posted, that be applied to the account. And then, Mr. Hassel, the court is going to order that you appear at the friend of the court office before Friday of this week to update them on your current situation with regard to employment. And Ms. Kraus, if the friend of the court, if Mr. Hassel is not employed, I'm going to direct the friend of the court to use your typical procedures of job search and so forth, so that we get Mr. Hassel moving in the right direction here. And then depending on what happens between now and August, Mr. Hassel, in terms of your compliance with any directives of the friend of the court to seek employment, the court will determine how we're going to proceed with the contempt then, okay?
Okay. I can give a little more than 500. I plan on making a payment, but you guys issued the warrant, and obviously it's been a little hard to find some work. Because if I got a warrant, I can't really get to work. So I'm glad that this is being taken care of. My only last question is, am I gonna be being pulled over in the process of looking for work, or is this gonna be like intermitted while I'm searching for work and finding a job? I have a couple places I've interviewed at and I'm waiting to hear back from, but I just want to know that me driving to and from a new job, I'm not going to be in this situation again, getting pulled over on the way to work.
So a couple of things. First of all, you have arrearages of $19,000, so you're free to pay however much you can pay whenever you can.
Okay.
I'm setting the bond at $500,
Okay.
so that you can get out, and we've got some money from you to post to the account, but it's also going to give you an opportunity to get out and work on your employment situation. In terms of driving, the warrant's been, the warrant's going to be recalled, so you won't have a friend of the court warrant out there. I don't know what other problems you might have with regard to driver's license. I have no other information on that, but there won't be any reason why you would be arrested based on something from the friend of the court.
Okay.
In terms of future action, though, again, that's all going to depend on what happens between now and August in terms of your compliance with directives from the friend of the court regarding your employment. And if you don't report to them, if you don't provide whatever documentation they're requesting with regard to your employment search activities, then you may be found in contempt and jail time may be imposed. But if you do follow those directives and report to them, then that'll be a different story. Okay.
Okay. My only last question is the amount I'm being ordered to pay. I can't even accumulate that kind of money, even on a $20 an hour job. I'm just trying to figure out how I'm supposed to, like, most jobs are paying $15 to $17 an hour on average right now. And that's not even, if you add that up, that's a little less than $2,400 a month after insurance and taxes. And then you guys are taking $1,200. And then I got a house payment. I got a 1-year-old child and I got 2 stepdaughters. And I'm just trying to figure out how I can come up with that kind of money, because there's just not a lot of jobs that are paying the amount I'm being charged right now. And I haven't got to see my kids in almost 6 months. I haven't seen Sebastian and Elena in over 6 months in a year. I've seen my kids maybe 7 times.
So there's a process for reviewing the amount of child support that you're being ordered to pay. And there's a process to have that adjusted or modified. And so when you meet with friend of the court, I think that needs to be one of your questions, is whether you qualify to have that reviewed at this time.
Okay.
All right, Ms. Kraus, is there anything else that you needed in terms of the order for going forward?
No, thank you.
All right, so Mr. Hassel, again, just make whatever arrangements you need to have made to have that $500 payment made, and then you'll be released, okay?
Okay, thank you, Your Honor.
And again, before Friday of this week, you need to report to the friend of the court office.
I need to come to them.
Yep.
And what am I just letting them know if I find work or if I don't find work, or?
They're going to direct you how to proceed further once you report to them, okay?
Okay. Is there going to be a paper sent to me explaining, so I just come up to the front of the court office then, or do I got to do a Zoom, or do I call them?
Nope, you need to go there in person. You will get some paperwork that explains in writing everything that I told you here today.
Okay.
Okay. All right, we're going to go ahead and disconnect at this time.
Thank you, sir.
right, we have Mr. Goff connected, so we'll go on the record in Brandenburg versus Goff. This is file number 09-13272. We also have Ms. Kraus here present by video on behalf of friend of the court. Ms. Kraus, can you give me an update about where this file is?
Yes, this hearing was adjourned from June 3rd to allow the defendant an opportunity to secure employment and to update the friend of the court with job searches or proof of efforts to modify support. The defendant did report a new employer and has obtained the appropriate documents to pursue a support review. No payment has been received from the new income withholding order. But friend of the court has not successfully contacted the defendant to discuss a payment plan. The friend of the court would ask the defendant to be ordered to contact friend of the court to set up a payment plan so payments are received until an income withholding is active. Additionally, we would ask the hearing be adjourned out 90 days to monitor compliance to November 4th.
All right, Mr. Goff, the court is going to order that you contact the friend of the court before Friday of this week to make arrangements, as Ms. Kraus has indicated. And then we'll set this for another review hearing, as she stated, in about 3 months. Do you have any problems with that?
No.
Okay. Okay, so Ms. Kraus, if you can put that into an order, and then that's how we'll go forward. Is there anything else that we need to address on this case?
No, thank you.
Mr. Goff, do you have any questions at all?
No, Your Honor.
Okay. All right, thank you. You're free to disconnect at this time.
Yep. You have a good day.
Thank you. Okay, Ms. Kraus, I did have on my docket a couple other files. I don't see anybody appearing by Zoom for either of these, but I do want to call them. One is Stephanie Moore versus Jeremy Carey. That's 09-13285. The record should reflect that neither party has appeared today for that hearing. And that was set as a hearing for suspension of recreational licenses. Is that correct?
Yes.
Okay. And did you still want to go forward with that suspension?
Yes.
Okay. And just for the record, that's with regard to Mr. Carey. He's the payer. Is that correct?
Correct.
And is he at least 2 months behind in his payments?
Yes.
Okay. And do we currently have an income withholding order with regard to him?
We do not. His obligation is $643 and the arrearage is $22,118.53. The last payment was received in November of 2023. The notice of the proposed suspension was mailed on April 23rd. The defendant did not pay the arrearage in full or request a hearing. Since the petition was filed by the friend of the court, there's been no payments or contact from the defendant.
Okay, thank you. So the court finds that the statutory grounds have been met for suspension of Mr. Carey's recreational or sporting licenses, and the court will sign that order once that's been presented. And then finally, I had Rochette versus Rochette, file number 1817101. Again, neither party has appeared on that file this morning. How did you want to go forward on that one?
Yes, a bench warrant issued on January 25th of 2023 for the defendant's failure to appear for a show cause hearing. The defendant posted bond at the Otsego Sheriff's Department in the amount of $600. This is an arrears only case with a balance of $229.50. The office would ask for the bond to be released to the friend of the court, so a portion can be applied towards the defendant's balance. And additionally, monies would be issued back to the defendant by paper check to the last known address.
Okay, thank you. The court will order that those funds be released to the account. And are there any other hearings that we need to set on that case?
No.
Okay. All right, and did you have any other files that I missed that we need to address today?
No, I don't believe so. Thank you.
Okay, great, thank you.
Mr. Krumka, this is supposed to be 10 minutes late. He might be here. I don't know if he's here now, but maybe not. Did you do that? Quit it. Is that all right? Oh, and then
Yes.
you need to turn it? Oh, I'm sorry. I thought it was in person.
So did I.
Yeah. Yeah, it was supposed to be in person.
Ms. Bailey, quick.
I thought Mr. Kremka was in person. I was originally supposed to be out of town today and Mr. Kremka was in person.
Yeah, everybody was supposed to be here in person. We're gonna.
We
see
can
if
come
he's
over in
present.
person.
Huh?
We can run over in person.
Well, he did call the court this morning and indicate that he was gonna be a few minutes late. So I'm gonna give him a couple more minutes and let's see what happens before I have you guys make the trip over, okay?
Okay,
So I'm just gonna put you on hold for a few minutes and I'll check back in probably in about 5 minutes.
okay.
All right, thank you.
Who's at that folder? Yes, he did. Yeah, he's got that. Mhm.
record in Kremkow versus Kremkow, case number 1415608. Ms. Bailey, quick, if you put your here.
Good morning, Your Honor. Miranda Bailey Quick on behalf of Celeste Field, who's present to my right.
Thank you. We're on the record here today. This is a show cause hearing for why Mr. Kremkow should not be held in contempt. The court notes for the record, this hearing was set for 9:15. It's now 9:35 by my clock. Mr. Kremkow did call the court and indicate he was going to be a few minutes late this morning. Ready, Mr. Kremkow?
Yes, sir.
Okay, why don't you come right over there and have a seat. So we do have Mr. Kremkow present here in court today. Ms. Bailey Quick, I did have a chance to review the show cause. So this deals with order that the referee issued for approval of out of international travel. Is that right?
That is correct.
Okay. And there was no objection filed to that. And your allegation is that Mr. Kremkow has not complied with that order by, signing whatever needs to be signed to allow the child to leave the country.
At the time of, it was that Mr. Kremkow signed the necessary paperwork to have my client renew the passport application. Mr. Kremkow is in possession of the prior passport, which is also needed in order to renew the passport. We would need that returned to my client in order for her to finish the renewal process. I will note for the court that this past Friday, Mr. Kremkow did provide a new passport, the paperwork with his signature and the correct notary information. He did previously provide back in the middle of May, the signed after we filed the show cause. However, the notary information did not match. The notary, Mr. Kremkow signed the notary statement and application dated May 5th. The notary signed the date of notarization as August 9th of 2024. As soon as we received that from the front of the court, my client provided him notice of that, and he still did not timely get that back to her. The most frustrating part of all of this is that the front of the court approved this back in March and directed that Mr. Kremkow timely sign the necessary paperwork. He didn't do it. He waited until after we filed the motion to show cause. And even still after that, Mr. Kremkow didn't do it. And after, again, providing him notice that the signature information wasn't going to work because it was going to be denied because the notary information didn't match his date. And he still waited until this past Friday, knowing that today was our court date. All of this delays my client from being able to proceed forward with travel with the minor child. And it causes my client attorney's fees and costs. But for bringing this motion before the court, we don't believe that Mr. Kremkow would have actually ever signed the motion or the passport application. And so that's the frustrating part of this. We would have withdrawn this motion. But again, we don't believe Mr. Kremkow would have actually followed through had we not filed the motion and had the court date not be set for today. Because again, he waited, even though we timely filed and noticed him with all of this in multiple different formats, by mail, by email, and through the Our Family Wizard, which is how the parties communicate. He chooses not to look at the communication and until he wants to. And he'll look at other communication, but he won't look at particular communication. And that's the frustrating part of this. And all it does is it impacts the minor child and it delays my client and it costs her more time and money with attorney's fees and costs.
So what needs to be done as of right now?
At this point, we have the signed application. We now need the passport that he has in his possession so that she can turn that in. Otherwise, that will cause a delay. Because otherwise, I believe the the government considers that a lost passport and they need that turned in with the application in order to proceed forward.
Okay, so that's the only thing you need.
That's the only
Sitting
thing
here
we
right
need
now.
still.
All right, Mr. Kremko.
Well, to begin with, she, after this, judgment came out and I were to sign this passport release. Just, what, 3 days after that order came out, she was already messaging me about why is it not turned in yet? So I was in communication with her as to, hey, I haven't received it yet. I don't have it. When I did get it, I messaged her and said, hey, it finally showed up in the mail. I'll get it taken care of. The next following day is when they filed for the contempt for today. The day after, I told her, hey, I just got it in the mail. So I got it taken care of. It probably wasn't within the 12-hour period that they wanted it in. The mix up on the dates on the thing, I had nothing to do with that. Maybe it was a mistake on my part. Probably was rushing around, not having everything together completely. But I didn't do that intentionally. I signed the paperwork and sent everything back to the front of the court so they had it and there was proof that I did send it back. Once they did, she messaged me and told me that the dates were messed up and I needed to do a new one. I was shocked. I wasn't expecting that. So yes, I didn't jump on it right then and there. Life's kind of busy and obviously me showing up today kind of shows I don't have everything, completely together, but I'm trying. And I got it taken care of and I sent it back, or actually I handed it to her in person. I had my son give it to her. As far as the passport, I was unaware of that. Maybe that's my fault. But like I said, the day after, I explained to her that I just got it in the mail from the front of the court. I still haven't received their copy from what they mailed to me that I was supposed to fill out and turn back in. I still haven't received that from them, but I received it from the front of the court. So that's all turned in, taken care of. I was unaware about the passport. I'll have to look for that and go from there.
Ms. Bailey, quick.
Your Honor,
Oh, go ahead, sorry.
And for the time and it's pushing back time and whatnot, as stated on this contempt stuff, she hasn't said anything to me about when she is planning on going on this vacation out of the country, but it did state in there for the winter time. And we're still pretty far away from winter, so I don't think the time is necessarily a big crunch or a big stress. But I mean, I'm turning it in as I can.
Okay, thank you. Ms. Bailey.
the winter time frame was when my client initially asked him back in last October. And he delayed and delayed and delayed. He delayed in refusing to respond to a community mediation. He delayed until we were forced to file a motion and then present in front of the court in March. It is not our obligation to update his address for him. In fact, we don't even know what his address is. It is our obligation to send mailing to his last known address that's on file with the circuit court. That is what we are doing. But yet we have went above and beyond and sent additional notice to him to the other formats where we know he'll get notice. He cannot say that he's not getting notice. We sent him the link to where he can print off the passport application signature page for himself. He refused to do that. It doesn't take from March until May to get mailing. That is his responsibility. It is not ours. If he wants to get notice, he needs to update his address with the circuit court clerk. It is not our responsibility.
Okay, is 14 days, if the court sets a 14-day time frame on the old passport, is that sufficient amount of time for you to do what you need to do.
If he provides the passport to our office, we will give him a receipt, so he has that.
Yeah, it's 14 days.
That's sufficient.
Okay.
But Your Honor, we are asking for costs and fees for having to bring the motion.
Right, okay. So the order was issued back in March, wasn't objected to. Mr. Krepkow, you know, I understand you have reasons for why you haven't complied with it. I don't find that any of them are adequate reasons or things that would have prevented you from complying with this order in a timely manner. Your non-compliance with it did result in them having to file this motion today, did result in Ms. Fial having to pay her attorney to come here to force you to do what you're just supposed to do voluntarily.
But a day after I specifically told her, hey, I just got it.
Yeah, you had,
That's when they filed
you
it.
had 2 months, almost 3 months since that day.
But I get all the other mail from front of the court. The
Yeah,
only
I
piece
know.
of mail that I do not get is from her.
I'm sure you got a laundry list of excuses. The fact is, you just didn't do it, right? So she had to pay her lawyer, drag everybody in here to court today to make you do what you're just supposed to do under the order. So when that happens, they're entitled to some cost fees. Ms. Bailey Quicken asks that you submit an accounting to the court, and then I'll determine what's reasonable based on what you submit, and the court will issue an order for that. In terms of the old passport, the court's going to include as part of that order that be turned over to you at your office within 14 days.
Could we ask that that be within 7 days? My client has an appointment with the post office for the passport application on July 9th at 1 o'clock with the minor child.
Okay, yeah, so 7 days.
Thank you.
All right, Mr. Kremkow, do you have any questions about what you need to do? Ms. Bailey Quick, do you have any questions? I'm gonna ask that you submit the order today.
I will submit
regarding
it
the
today.
passport, and then along with that, I'll issue a separate order as to the sanctions.
Okay. Does Mr. Kremkow want to provide a current address so that we can send it to him?
I'll let you guys discuss that off the record. I've got to move on with my docket at this point. So, thank you. Mr. Dundon, are you here on behalf of Mr. Robinson? Is that correct?
Yes, sir, Your Honor.
Okay. I just need to adjust things here a little bit. Okay. Right, I'm not seeing Miss Robinson. Is she represented to your knowledge?
No, Your Honor. I did get a bizarre call from someone who said they were, but he's not an attorney, and we figured out what was going on. But I just spoke to her, I believe, on Friday. I actually have talked to her here and there and mentioned that I proposed that we try mediation, and I believe she agreed, but again, I don't want to speak out of turn, but.
All right, well, let me go on record in that
Yes,
case officially here. So this is Robinson versus Robinson, case number 2419660. This was set for 9:30. It's now 9:50. Mr. Robinson is present along with his counsel. Ms. Robinson is not present. And so This is just set for a scheduling conference here today. Did you want the court to just order this to mediation, Mr. Dundon, and see where it goes from there?
Yeah. Yes, Your Honor, if you could, that'd be great. And then I guess we'd ask for 120 days of discovery if we could. And then hopefully it's all unnecessary, but I guess I want to cover my bases.
Sure. Okay, so we'll set discovery for 120 days, mediation to occur within that time. And any other scheduling dates that you would like to address today?
No, sir. I think we're good to go.
Okay, I will put that into an order, and then the court will send out notice of the date and time for that next status conference at about 120 days. And if the parties are ready to finalize things, we can take proofs that day. If not, then we can see where things are at. Thank you, you and your client are both free to disconnect at this time.
Sounds good. Thank you, Your Honor.
Okay, Mr. Rolla, are you able to hear me okay?
Yes, Your Honor. Good morning.
Good morning, thank you. We'll go on the record in Wagner versus Heim, and this is case number 2419691. The record should reflect that both parties are connected today by Zoom, along with Mr. Rolla on behalf of the state. This is set for entry of a consent judgment of affiliation here today. Mr. Rolla, I do have the proposed orders. Is there anything that you wanted to state here today for the record?
Other than the court taking some very brief testimony from one of the parties, we believe the order should be entered.
Okay, Mr. Heim, are you able to hear me okay?
Yep.
Okay, Mr. Heim, part of the proceeding here today is to establish that there's no dispute that you are the father of Amelia Wagner. Do you understand that?
Yes, Your Honor.
Okay, and I see that you've acknowledged that by signing these orders here back on June 28th. Is that correct? Is that your signature?
Yes, Your Honor.
Okay. And so by signing those documents, is it you're not contesting that you're the father? Is that correct?
Correct.
Okay, and you're not contesting entry of these orders today?
Correct.
Okay. And Ms. Wagner, you're the mother of Amelia, is that correct?
Yes,
Okay. And you understand that the orders that we're entering today establish that Mr. Heim is the father?
yes,
And they're providing that the two of you will share joint legal custody and that you would have primary physical custody with parenting time for Mr. Heim, as you agree, is that correct?
yes,
And as the mother of Amelia, is it your view that that is in the best interest of your child?
yes.
Okay, thank you. All right, so the court will enter those orders today. If either of you would like copies of those for your records, you can get those from the prosecutor's office. Mr. Rolla, anything else that we need to address for the record today?
No, Your Honor, not in this case. Thank you.
Okay, Ms. Wagner, do you have any questions at all?
I do not.
Mr. Heim, did you have any questions?
Nope, I'm good.
Okay, thank you. That's all for today, and you're both free to disconnect. Mr. Rolla, I'm going to call a case that was actually set earlier than this one. And that is,
Mullins v. Singer.
yes, Mullins v. Singer. And that is file number 2419663.
For the
Sir,
record,
are you Cody Singer?
Yes, sir.
Okay, am I pronouncing your name correctly?
Yeah, Singer. Just say it in 2 words, Singer.
Okay,
Yeah.
okay. And the court notes for the record that this was set for a hearing at 9:30. It's now almost 10 o'clock. I don't see Miss Mullins present. Mr. Rowland, have you had any contact with her at all?
she advised her office she's not going to be present for the hearing, Your Honor.
Okay. So Mr. Singer, we're on the record here today to establish child support for Caleb and Bella. Do you understand why we're on the record here today?
Yes, sir.
Okay. And do you have any objection to the court entering these orders requiring you to pay support on behalf of those 2 children?
No.
Okay. And I know that you signed these documents back on June 28th. Is that correct? Is that your signature?
Yes.
Okay. So based on that, the court finds it is appropriate to enter those orders today. And Mr. Singer, if you wanted to get copies of those for your records, you'd be able to get that from Mr. Rolla's office. Did you have any questions at all?
No, I talked to the child support lady. She pretty much kept me like what I need to know. So I'm pretty good on what I need to do now.
Okay. All right. Very good. Thank you. That's all for the hearing today. And you're free to disconnect at this time. And,
all right. Thank you.
Mr. Rolla. Thank you.
All right, thank you.
Okay, our next hearing is set for 10 o'clock. We're just a couple minutes ahead. I see one of the parties present, so we're just going to take a short break to allow the other party to appear. Ms. Kraus, I might need you if are you there? Okay, we've got everybody connected. We'll go on the record in Morrison versus Morrison. This is case number 2319363. The record should reflect both parties are connected by Zoom video. This was set for a status conference today. We did have a previous hearing back in June, which neither party did appear for. And it's a follow-up to a hearing that we had back in March where we tried to enter judgment of divorce and determined that the plaintiff was pregnant at that time. Ms. Kraus, does a friend of the court have any information as to the status of the paternity issue?
No, there's actually not been any contact since March when the plaintiff requested that information be resent to her.
Okay, Ms. Morrison, can you tell me what's going on with your case here?
Yes, I had a conversation that I remembered having with Jesse, and I guess there was a misunderstanding between him and I where I thought he was filling out paperwork and he thought I was filling out paperwork, and neither of us realized until just before our meeting today that this misunderstanding happened.
Okay, so you still want to go forward with the divorce, is that correct?
Yes, please.
Okay, and Mr. Morrison, you as well?
Yes, sir.
All right, so Ms. Kraus, just so I'm clear, they picked up the paperwork, they just haven't done anything with it yet, is that right?
Correct. It was mailed out. It wasn't picked up.
Okay, Ms. Morrison, do you still have the paperwork?
I would have to look, but I do not believe so. I had some people come through and clean the house recently, right before the pregnancy was over, and a lot of stuff has been misplaced. So I couldn't tell you for sure if I have that paperwork or not right now.
Okay, so you need to go to the friend of the court. You need to get that paperwork from them. I'm not going to have them send more copies out to you. So the obligation is going to be on you or Mr. Morrison, frankly, either of you can do it, to go to the friend of the court and get that paperwork. The court's going to set this for another hearing in 60 days. If there hasn't been any progress at that time in terms of the paternity issue, then the court's going to dismiss the case. So, you know, at that point, you guys have had since March, so we're 4 months here, nothing's happened. If nothing happens in the next 2 months, I'm going to assume that neither of you is really interested in finalizing this divorce, and I'm just going to dismiss your case. Do you have any questions, Ms. Morrison?
No, Your Honor. Thank you.
Mr. Morrison?
No, Your Honor.
Okay. All right, thank you. We'll send out notice of the date and time for that next hearing in 2 months, and you're both free to disconnect at this time.
Thank you.
Thank you, Your Honor.
All right, we also had another 10 o'clock hearing, Goddard versus Goddard. That was case number 2319521. Looks like court had set this for hearing back in June. Neither party appeared for that hearing in June. So the court set it for one final hearing today. Again, that was at 10 o'clock. It's now 10:06. Neither party has appeared on that file here today. So the court's simply going to dismiss this case and close out the DM file. I know that it's joined with a support file. Ms. Krause, have either of them been participating in any hearings related to the support issues?
There had been contact from the defendant, but outside of that, in regards to the uniform support order that was entered in April, outside of that, there hasn't been. So I guess the office would request, the front of the court would request that the order be unconsolidated and for us to review what actions need to be taken in regards to the DS case.
Yeah, okay, I think that's appropriate because I think that would need to go forward outside of what's happening with the DM file. So they have been consolidated. The court will dismiss again the DM file. Did you want me to set any kind of hearing in the support case, or are you going to have that set before the referee?
If appropriate, we could go forward with setting it in front of the referee.
Okay. Okay, thank you. Any other matters with those files that we need to address today?
Not that I'm aware of. Thank you.
Okay, thank you. Our next hearing is set for 10:30, so we'll take recess until that. All right, Mr. Glenn, are you able to hear me okay?
I am. How are you?
Okay, good, thank you. I'm just waiting for Mr. Thompson to connect, so if you could just hang on the line here for just a minute.
No problem.
Okay, Mr. Glenn, I've got Mr. Thompson signing in right now, so should be able to get started momentarily.
No problem. Thank you.
Okay, we've got everybody connected, so we'll go on the record now. This is Martel versus Simpkins, case number 2218919. If I could just have counsel put your appearances on, starting with plaintiff, please.
Morning, Your Honor. Dave Glenn on behalf of plaintiff Martels.
Thank you, Your Honor. Jason Thompson on behalf of defendants James and Jessica Simpkins.
All right, thank you. We're on the record here today. Mr. Glenn, this is your motion, and it looks kind of like a two-part motion to me. First of all, there's a request for some discovery and a court order to compel discovery. And then it sounds like you're asking for some relief with regard to the placement of the boat hoist. And so, Mr. Glenn, anything that you wanted to state today by way of oral argument?
Yeah, thank you, Your Honor. I don't know if you'll recall or not, but when we were last with you in person at the settlement conference, it was my understanding when we adjourned from that conference and ultimately the court indicated that it would extend out discovery for the specific purpose of the parties exchanging discovery with regard to the specifically to the cameras, because I think my understanding, if my memory is correct, we all agreed that that was right for summary disposition after the details of those cameras were made available. That way we could present to the court whether or not that was an unreasonable invasion of privacy or a nuisance based on the type of cameras, the what those cameras were capable of doing as far as zoom, potential night vision, things like that. We just needed to get that information for the purpose of filing a motion for summary disposition and possibly Mr. Thompson doing the same to eliminate that portion of the case. And I left, and I think all parties left your chambers thinking that was the next step. Unfortunately, we've asked now twice for that information early on in the case, and it was never provided. Motion to compel was brought earlier in the case. They did provide some answers after the first motion, after the court ordered them to do that in the first motion to compel, but nothing about the cameras was provided back then. So we asked again after we had our conference for the purpose of a motion for summary disposition, and we've received nothing as far as a response other than the response to this motion. Also, what we were under the understanding at the last settlement conference was that the boat hoist was going to be going in pretty much that day, and that it wouldn't be an issue as far as close to the property line, the riparian line, because they indicated it would be 4 foot from that line. Unfortunately, when it was actually put in, it pretty much was put in the exact same spot that it has been the last couple years, which you can see from the pictures when you do the shoreline monument out to that second monument out to the monument by the boat hoist, that it does encroach. So not only is it not 4 feet from that line, it's encroaching over the line. And it just seems like, it's almost intentional at this point that they're not trying to get along with our clients. We had some clear instructions, I think, from the court after we left, and both of those things didn't occur. So we're to a point, this isn't the motion I wanted to bring. I wanted to bring a motion for summary disposition, put all the cards down for the court to decide on the cameras, but we can't do that because we don't have the information that we need in order to file that motion. And we were disappointed that the boat hoist went in exactly where it was last year after it was indicated that it was going to be 4 foot on their side of the line. So we're just disappointed that occurred. And at this point, it just doesn't look like they want to play by the rules as far as this litigation is concerned. And if that's the case, I mean, we're now on our second motion to compel, and we're getting dangerously close to MCR 2.313 B2C, which is, potential default judgment in our favor. That would be our recommendation at this point for the court to consider, because it just doesn't look like they're going to play by the rules to get this presented properly to you, Your Honor. So I'll leave it to your better discretion on what you'd like to do, but those are the facts as we see it, and that's where I thought we left the last conference. And unfortunately, things didn't play out the way I anticipated they were going to after we had that conference a few months ago.
All right, thank you. Mr. Thompson?
We do object to the scope of the discovery, Your Honor. It asks the Simpkins family to divulge, the nature and location of all their security cameras that would limit the effectiveness of those security cameras. I think it's telling that plaintiffs have brought this action, but they don't know what the security cameras are. They don't know if they're invasive. They don't know what they do. They're on a fishing expedition. All they're going to discover, if the court does grant this discovery, is the details of the security system, which reduces its effectiveness. The Simpkins put this security system in to protect their home, to protect themselves and their children, and they don't want to divulge to their neighbors or to anybody else where all the details about the cameras, because that's just going to blunt the effectiveness of those, Your Honor. So we are objecting to the scope of discovery. Further, there's a request for every image that could contain the Martell's property. And I mean, my understanding from other images I've viewed in prior motions and things like that is that the Martell properties in the background of at least some of the Simpkins cameras that are on the Simpkins property, but the Martell property is in the background. So I don't know how effectively we could produce every image the security system has ever generated. And I think that would also be overbroad. As to the contempt issue, Your Honor, we don't have a survey this year. We have a survey from last year. Mr. Simpkins put his affidavit that he moved the hoist in response to last year's survey, and that this year he specifically instructed them to move it further from the line than it was last year. A surveyor hasn't came in this year. I understand that's a problem with timing. Mr. Simpkins would welcome a surveyor putting a marker out maybe 40 feet from shore, because as the court knows and as the court ruled, riparian lines aren't exactly parallel with the land lines. There is a bit of an angle to this one. This isn't the dock itself, it's the boat hoist, I guess, that's at issue. Mr. Simpkins specifically instructed his installers to put this over several feet from where it was last year. So he doesn't believe it infringes. A surveyor hasn't went out there this year. If a surveyor goes out there and puts a monument out, Mr. Simpkins is certainly willing to observe that. He would prefer to not have to take time to deal with this issue. So we're asking that the court deny the request for contempt, or in the alternative, have a full evidentiary hearing. And as to the motion to compel, we're objecting to the discovery that the plaintiff seeks in this case. Thank you.
Thank you, Mr. Glenn. It's your motion. Any reply?
Yeah, briefly, Your Honor. So in regards to the information about the cameras, we have an idea of what they can do. In fact, in this litigation, I think actually the one prior, they provided photos of what those cameras can see. The problem with their argument is, if they don't provide that information, they're just going to use that information against us when we bring a motion and say, well, actually, this is what the camera is capable of. So we need to know precisely what the camera is capable of to determine whether or not it is a nuisance, whether or not it is an invasion of privacy. If that has a ridiculous zoom on it or night vision capabilities, that is far beyond what the human eye can normally see and observe from the outside. So that is extremely relevant. We have an idea, we suspect that those capabilities are in those cameras. However, the fact that they don't want to provide that seems to indicate to us, at least, that probably does have those capabilities, which is very concerning. And yeah, we're not looking for the information about every single camera that they may have. If they want to limit the scope, Mr. Thompson could reach out to me, and I would have agreed to limit the scope to the cameras in the immediate vicinity to the Martell property, specifically the one at the apex of the house. And I believe there's also one near the fence line that has some potential recording capabilities. Those are the ones we're concerned with. I think the court knows at this point that those are the ones that are at issue. And it's extremely important for us to know at least the make and model of these cameras, so we know what capabilities they have. I don't think that's unreasonable. I don't think that breaches their security apparatus at their home. I just don't buy that argument. We've asked for it twice now, and we have not received it. I did not receive an objection to our discovery. The only objection I've received at this point is from Mr. Thompson at this hearing and in response on Friday to our motion. So we need the information, and more importantly, they're just not playing ball at this point. We're not moving this thing forward because every time we feel like we have a path forward, it falls apart when we try and execute that plan. So it was clear that that information needed to be exchanged after our last settlement conference. So each of the parties could file their respective motion for summary dispositions, but we can't do that because that information wasn't provided. As far as the survey, that line has been surveyed ad nauseum. There are monuments out there based on that survey that are drilled into the bottomlands with buoys sticking up. So there is no question, no genuine question as to where that line is. And there's no question that when you draw a rope from the monument on the beach out through that middle point out to the end point, that hoist is encroaching. So I don't think it does us any good to go out and have a surveyor confirm that and delay this another few months. It's unnecessary. They know that they're encroaching. All they have to do is move their hoist over, and that's resolved. Thank you.
Okay, I did have a chance to review the briefs that were filed by each party along with the exhibits to those briefs. First of all, looking at the issue with regard to discovery, as council's aware, Michigan has a very broad policy regarding discovery. Any information that's relevant or reasonably calculated to lead to relevant or admissible evidence is discoverable as long as it's not privileged. In this case, we're not dealing with information that would be privileged. So the question is it relevant and is it within the scope of discovery? One of the claims here does involve the cameras and potential invasion of privacy, and where does that line meet? And I know that, in my discussions with counsel off the record in chambers at the settlement conference, we did discuss that as an outstanding issue and what is the legal standard, and that was something that may be right for a motion for summary disposition as to whether that standard is violated. So the court finds that the cameras are relevant to some of the plaintiff's claims here. I do think a couple of the discovery requests are overbroad and are frankly would have little relevance to an argument that the cameras are violating any right to privacy of the Martells. But I do think some of them are relevant to it. So the court is going to grant the motion with regard to interrogatories number 1 and 2, and the request for production 1 and 2. The court is denying the request with regards to requests for productions 3 and 4. Again, I don't think they need the Simpkins need to produce all photographs or stored videos that have ever been taken, and I don't think the instruction manuals, sales receipts, and so forth are relevant. I think plaintiffs have access to the information through the first interrogatory, and they can look up instruction manuals and so forth to the extent that they want that information, but I don't think the Simpkins should be required to produce that. So again, the court's granting the motion in part with regard to interrogatories 1 and 2 and requests for production of documents 1 and 2. The court's denying the motion with regard to 3 and 4. I also agree that the Simpkins have a legitimate concern about who may get this information regarding, from a security standpoint. So Mr. Glenn, I'm going to ask you to draft an order and submit it under the 7-day rule reflecting the ruling of the court on the motion to compel, and include in that the plaintiffs are not to disclose the information regarding the security cameras to any third parties. So that information is just to be maintained and used in this litigation only. And so in terms of a protective order, the court would order that information not be disclosed outside of counsel. With regard to the violation of the property line and the boat hoist, I'm kind of looking at this under kind of a show cause standard. Is there enough evidence that there's a potential violation there to proceed? And I think based on what was submitted by the plaintiffs in their motion with regard to the pictures in the survey, there's sufficient evidence to have it go to a hearing. I don't think I can make that determination on the record before me because frankly, the pictures aren't clear enough. And I think that I would need to have an evidentiary hearing before I could find that there's any kind of violation or contempt here. So Mr. Glenn, I'm going to leave that all in your court to the extent that your clients want to proceed with the contempt for the boat hoist being over the line. I'm going to ask that you notice that up for a 2-hour evidentiary hearing. I think that would be sufficient. And then, in terms of what would need to be produced, whether it's a new survey or whatever, Mr. Glenn, if your clients are asking for a finding of contempt, obviously the burden is on you to go forward. So you would need to, be prepared to present whatever evidence would need to be presented at that evidence or at that hearing for the court to be able to find a violation. So again, to the extent that the plaintiffs want to proceed on that, again, I'm going to leave that to them and Mr. Glenn to set that for a 2-hour evidentiary hearing. And the court will take testimony and make findings as appropriate. And then if you can include that in your order as well, Mr. Glenn.
Okay, can do that.
Mr. Glenn, anything further that we need to address on this case today?
A couple things, Your Honor. I don't know if Your Honor is willing to consider attorney fees for the motion to compel. It is our second motion to compel at this point, and I did not receive an objection prior to having to file that motion to compel. So I just asked the court to consider some fees in that regard. And also, I believe our scheduling order from the last settlement conference, we have a deadline for motion for summary dispositions coming up. And obviously, I think that'll have to be pushed back because we don't have this information yet. So.
Okay, so with regard to the request for any kind of discovery sanctions, I view those as being appropriate once there is an order in place on a motion to compel and if there's a violation of that order. So I don't find that any sanctions are appropriate at this time. And I find that, because the court isn't granting the motion in full, that's also the basis to find that sanctions aren't appropriate. With regard to extending the guideline or the scheduling dates, I don't have that scheduling order right in front of me. What is the current motion cutoff?
Coming up shortly, right, Mr. Glenn, like a couple weeks perhaps?
I think it's the end of July. Let me confirm that.
I know I ran past my 45-day reminder a little while ago.
Okay, so we currently have this set for the final bench trial on October 3rd. So in light of the proceedings today, the court will set the motion cutoff for the court's September motion day. So the one at the beginning of September. And Mr. Glenn, if you can include that in your order as well.
Do you know specifically, Your Honor, what date that is?
3rd?
That would be September 3rd.
Okay, so September 3rd will be the new cutoff for dispositive motions, just to be clear.
Correct.
And Your Honor, just so I'm clear, that's the date to have it heard by?
Correct.
Okay, thank you, Your Honor.
Yeah, filed and heard by that date.
And one final thing, Your Honor, I forgot to mention it before. How long do they have to get answers to the discovery to us?
Oh, I'm sorry. Can you do that within 14 days, Mr. Thompson?
Well. Yes.
I'm sorry. Okay, all right, so yeah, within 14 days of the date that the court signs the order, Mr. Glenn, so not today's date.
Okay. All right, thank you.
Okay, thank you, that's all, and all parties are free to disconnect at this time.
Good morning, Your Honor.
Morning. Okay, looks like we've got everybody connected. So we'll go on the record. This is Ryman versus Johnston, case number 2319394. If I can have Mr. Ryman, are you there?
I am, Your Honor.
Okay. So we have Mr. Ryman present, representing himself as a plaintiff. We have Mr. Couch here on behalf of the Johnston defendants. Is that right, Mr. Couch?
Correct. Good morning, Your Honor.
Okay, morning. And then I did receive a notice from Mr. Carey's office indicating that he and his clients don't take any position with regard to the motion here today and that they were not going to appear. So I think we can go forward. And Mr. Couch, this is your motion to compel the deposition of Mr. Ryman. And I guess the one thing I want to say before we get started, I view this as a very limited issue here today, or a very narrow issue. I know there's a lot of discussion in both sides' filings about the deposition of the Johnstons and whether that was properly noticed and so forth, but I don't have a motion for Mr. Ryman in front of me here today. I only have a motion from Mr. Couch. So the only issue that I really see as relevant is whether or not Mr. Ryman has failed to comply with proceeding with the deposition. So Mr. Couch, as to that issue, any argument that you want to present in addition to what's in your brief?
Very briefly, Your Honor, and I just want the court to know that I primarily filed this motion because I'm seeking the court's assistance in helping me lower the temperature on this case. There's certainly a lot of background to this case, and there are a lot of personal feelings between the parties. Complicating matters somewhat is the fact that Mr. Ryman is representing himself as counsel. So, we've got plaintiff's counsel and plaintiff being one and the same. As I set forth for the court, I properly noticed Mr. Ryman's deposition to occur on June 24th. He and I had a telephone conversation. I certainly understood him to say that he would appear, but he was placing certain conditions on that. And I don't believe that the court rules require those conditions. I indicated to the court that he said he would appear if we would do it in Bay City where he lives, and also only if my clients testified first. And we agreed to disagree. I said, Mr. Ryman, I need to put this matter before the court, and that's what I've done. To try to expedite matters, Your Honor, I did give the court and plaintiff's counsel several dates. July 12th is no longer open on my calendar, but July 15th, 16th, or 17th are wide open. I'm simply seeking a court order that Mr. Ryman has to appear for his deposition on one of those dates. Hopefully he's checked his calendar in the interim. I would like to do it in my office. I'm happy to go up to the county where the case is pending if necessary, but if Mr. Ryman lives in Bay City, my Grand Rapids office is kind of an equal distance between the two locations. And in addition, there has been some delay in discovery caused by this. And I would respectfully ask the court to enter an order adjourning our remaining scheduling order dates by 90 days. We have a facilitative mediation on the books for July the 26th. Discovery is currently scheduled to end on August the 4th. It would be a little tight if we were to do Mr. Reamond's deposition mid-July and still have that discovery cut off. I want the court to know, though, that we've been working hard in going forward with discovery. Of course, the parties have exchanged initial disclosures. We've had a couple of experts take a look at the properties up there. We're just waiting for their final report. So it's not as if the parties have not done anything and we're coming before the court asking for more time because of that. It's just that I've had this wrinkle with trying to get Mr. Reamond's deposition. And then the last request that I would make, it's not in my motion. I just don't want there to be an issue at Mr. Reamond's deposition. I would like to videotape it. It's been my experience that when emotions are high in cases, a videotaped discovery deposition is not a bad idea. I think it just keeps everything cleaner and more transparent. So I wanted to request that from the court right now as well and see if that could be added into the order.
All right, thank you. Mr. Reamond, anything that you wanted to state in response today?
Yes, thank you, Your Honor. Judge, I don't know what Mr. Couch is talking about with all this high temperature. There's only been one person causing a problem with discovery in this case. And although Mr. Couch makes a really nice presentation and appearance and sounds very nice and cooperative, he has been the only attorney of the 4 on record for Mr. Johnston to, well, although they've all filed improper motions, which again will be part of my motion regarding his client's failure to show up for their depositions. Mr. Couch's first thing he did in this case was ask for a 90-day extension, and he asked all counsel to agree that no depositions would take place in that time period, etc. And although I was very cautious of that, for a very important reason, Your Honor, I did eventually agree to that. And that's how we arrived at the August 4th date. But as the court can see from my exhibits attached to my response, I've been trying to take the defendant's depositions by cooperation since September 18th. So
okay,
over
Mr.
9
Reamond,
months.
Mr. Reamond, as I indicated at the beginning, this isn't a motion to compel from your side. So to me, whether or not you've had problems with discovery, if you had that, then you need to file motions to compel, and that's not in front of me today. So I only want to deal with the issue of you and your deposition, okay?
Okay. Yes, thank you, Your Honor. I was just responding to Mr. Couch's preface to his arguments of how cooperative he's been and how uncooperative I've been. That's just not true. But as to this motion, Your Honor, I am not asking sanction or seeking an order at this time. I am going to put it all together for the court so you can see everything that's going on in this case. And I will be asking for sanctions because in addition to the other frivolous motions that have been filed in this case is completely frivolous. Under MCR 2.625, of course, counsel signing motion to compel discovery is obligated to put forth facts and law that would support that. So the first thing he has to prove is that I did not provide discovery. I'm not objecting under the deposition notice in any event. I didn't, and that's proper notice. And I did not refuse to appear for my deposition. I was concerned that Mr. Couch was laying that up, that he was trying to set a circumstance where he couldn't make that argument. So I did put everything in writing, Your Honor. He had a meeting with me where he threw a fit because I wouldn't agree to cancel the Johnston's depositions because of the history. And I explained that history to them, and the history is in the exhibits attached to my response. To the most part, Your Honor, there's more. But Mr. Couch wanted me to cancel his client's depositions. And when I refused to do that, only because he wouldn't agree to give me a date to do his clients. And Your Honor, Mr. Couch first asked for deposition dates to take my deposition. Let's stay on mine. In March, early March, and he suggested several dates for early May. I agreed to those dates, at least several of them, and we arrived at a date that he picked. I believe it was May 9th. On May 8th, and then we had agreed, Your Honor, to do the Johnstons and my debt. The day before that, so 2 months after we said it, he canceled it. He just sent an email from his secretary saying, I know we had reserved tomorrow, but we're going to cancel that. So nobody asked my permission. Nobody asked new dates. Mr. Couch, in that email canceling that, he asked for, I'm sorry. Yes, he asked to consider additional dates. So I immediately responded to him on May 10th, or I'm sorry, on May 9th, and said, why don't we use June 24th? Because I had reserved that, Your Honor, for deposition of the neighborhood witnesses, but most of them have provided affidavits now to me that counsel has. So I said, we won't need that date anymore. Why don't we use June 24th? And I would like to take, I gave an order of the deposition to their clients, and I said, then I will, be available that date as well. And I suggested that we pick a neutral place because there's appearances of attorneys in this case for the Johnstons. That one lawyer is in Traverse City, although his appearance shows Detroit, but he's in Traverse City. Then we have Grand Rapids with Mr. Couch. We have Shelby Township on the counterclaim and appearance on this case, and then Brighton, I believe. And of course, Mr. Carey and his associate are in Grayling. I live in Johannesburg. One of the lawyers of record in this case, Ms. Lehman, has her summer home in Johannesburg. The Johnstons are in Johannesburg. So I didn't insist or demand, I just suggested, why don't we pick a neutral location or a halfway point? I suggested Bay City. I certainly didn't insist on it. And when I got no response, Judge, not one of the 6 lawyers on the case responded to that email. That's when I set the deposition. I got back from vacation and found that Mr. Couch, although I had asked him to be aware that I would be out of the country and not have access to my email, when I got back in the first week in June, I saw that during that time period, Mr. Couch did in fact set my deposition by email only. So that's when I quickly set the Johnstons' deps. I gave them 13 days notice. Again, let's stay with my dep. You can see from my emails, Judge, I went out of my way to tell Mr. Couch, don't try to claim I won't show up because I want to be there. I'll be there on the 24th at your office. Let's get my dep done. And I'd ask the court to consider what evidence, what factual support has Mr. Couch put in this motion that would make it not frivolous. That his claim that I canceled is coming from his word, which is not evidence, and it directly contradicts the admitted writings between the parties, which I say 3 times in the 3 different exhibits that you have, Judge. Mr. Couch, I will be there for my deposition. After he filed the motion, I said, are you canceling my deposition? And he said, yeah. So there's no support. There's no factual support for any relief requested by Mr. Couch. Judge, here's why it's important. And going to the request to adjourn, that the property at issue is my home. I can't use my home because not only did it flood, which took out all the, the carpeting, the flooring, the furniture, there's mold on the walls, there's mold everywhere. To the extent I've been able to clean most of it, but also, Judge, there's a river that flows down the middle of my driveway. Now, I tried for 10 months or more to stop that. Every time it rained, I would repatch it up. I'd get out there with my wheelbarrow, spend hours putting that back together, but you can't beat this water. And so I told Mr. Couch early on, let's just keep this moving because when this summer comes, my biggest flooding is in July and August. So that's why I was concerned about adjourning it the first time. And here we are again. He skips his client steps. He cancels mine and wants a 90-day extension, knowing that that's putting my property at risk again. So what I suggested, Your Honor, is I have found the excavator who built the ditch the first time, who set it all up properly. And I submitted to Mr. Couch that excavator's estimate for putting it back the way it was so that my house will not flood during this. I can fix it up. I can live there. I can come in my driveway. and I will pay for it. I just want him to restore it so that, not only am I mitigating any future problems, but I can use my home at least in the meantime, rather than just come in and out on four-wheelers or occasionally with, you know, for a weekend. And also with regard to the scheduling of the new dep dates, counsel through his clients know that, in July and August, that's the reason I have this property. My family, my kids, our friends take vacation through that time period, and they come and stay with us. So I will, depending what the court decides, I will, of course, make myself available, and I could do some of those later dates in July that counsel has suggested. But I don't think it should be pursuant to a court order. I think it should be pursuant to me and Mr. Couch and the other lawyers, compromising and encouraging each other to come up with a good plan to do these depositions. I'd ask the court to deny the relief requested, pending, again, my motion asking for the relief regarding the Johnston deaths.
Okay, thank you. Mr. Couch, it's your motion. Anything that you wanted to say in response?
I would only add very briefly, Your Honor, that the initial request for an extension of the scheduling order dates was due to some health issues that my partner in Traverse City was having, and he asked me to take over the case. And I had a 2-week trial out of town around the time that I took over the handling of the case. That's why I asked everybody to adjourn the dates. So I just don't want the court to think that nothing's being done on this case, and I wanted to further explain why that previous adjournment was requested.
Okay, I did have a chance to review the written submissions of the parties, and obviously I've had an opportunity to hear from each side here today. Addressing the main issue of the motion, which is the motion to compel the deposition, I don't know what happened on the phone call. There is no record of that. I know what the parties provided in their emails, because I did have a chance to review those. And I don't think that there's a basis for sanctions at this point against Mr. Riemann, primarily because I do think that, Mr. Couch, that your motion was a little premature in that Mr. Riemann, at least in writing, never refused to appear for his deposition as scheduled. And rather than leaving that scheduled to see whether or not he did actually appear, which of course, if he hadn't, then I think there would have been grounds potentially for some type of sanction at that point. But he never had the opportunity to either appear or not appear, because you did indicate to him prior to that date that you were just going to go forward with the motion. And in writing, at least, again, I don't know what the conversation was on the phone, but in writing, at least, he never directly refused to appear. I get the argument that it was kind of couched in terms of whether or not your clients appeared for their deposition that he scheduled, but through his express language, he never indicated that he wasn't going to appear unless they appeared, or that he wasn't going to appear. So I do think the motion is premature in some ways, and therefore there isn't grounds for the court to issue any kind of sanction. I do think, though, in the interest of moving the case forward, that it would be appropriate to order that Mr. Riemann pick one of the 3 days set for July, and notify Mr. Couch's office within the next 3 days from today's date as to which of those dates that he's going to submit to the deposition. And the court would order that that deposition occur based on the date that he provides within the next 3 days. In terms of how that deposition takes place, the location, I think, that's up to your office, Mr. Couch. I think you just need to notice it for a reasonable location. In terms of how it's taking place with regard to video or not, under MCR 2.315A, parties can take depositions that are authorized under 2.306, which this one is, by video, simultaneous video and audio recording without leave of court or stipulation, as long as they comply with all the other provisions of 2.315. So I don't think that's something that the court needs to order. Again, Mr. Couch, I think you're authorized to do that under the court rule. And again, as long as you're otherwise complying with 2.315, I think Mr. Riemann can't really reasonably object to that. So again, I think that's already authorized by court rules. Just in terms of the temperature of this case, you know, I agree. I think there's a lot of back and forth here that could be avoided and might result in some better communication and cooperation among the parties. Certainly, Mr. Couch, I'm fully aware of Mr. Riemann's status with regard to his bar association. That doesn't need to be repeated in every single motion. Certainly doesn't need to be backed up by written exhibits. I think to the extent that that means anything in the context of a motion to compel discovery, I don't think it's relevant at all. And to the extent that your side continues to bring that up, I think that's just a way of, you know, trying to get at Mr. Riemann and from a personal level. I don't think it's called for. And Mr. Riemann, you know, some of the emails that you submitted on your behalf, you're certainly making some derogatory comments directed at counsel and at his clients, which you absolutely do not need to make, and which is unprofessional and certainly doesn't help the situation either. So I think both sides would be well advised to back off of personal attacks and keep this on a professional level. This is litigation. This isn't an opportunity for everybody to engage in personal attacks. So I think that could go both ways. And I think to the extent both sides start doing that, I think everybody will cooperate a little bit better as we go forward. Given the delays that have occurred, I do think it's appropriate to extend the discovery dates out. So the court will also grant the request to extend those dates out 90 days. And so, Mr. Couch, I'll ask that you prepare an order and submit that under the 7-day rule. Number one, extending the discovery dates. And number two, providing that your motion to compel is granted to the extent that the plaintiff has to provide to you notice of which of the 3 dates that remain that he's going to submit to the deposition, and that it occur on that date, on one of those 3 dates. Mr. Couch, do you have any questions about what needs to be in the order?
No, Your Honor, thank you.
Okay. All right, thank you. That's all for today. And all parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Good.
And you said Duchesne was by Holly? Is that what you said?
Mr. Duchesne, can you hear me okay?
Yes, sir.
Just need a minute here to rearrange the courtroom. Butts, we're going to address your case in just a minute, okay? I'm running a little bit behind.
Yes, sir.
Thank you.
Is that one of ours, Judge?
That's what I thought. Okay, ma'am, are you Mrs. Harding?
Yes,
I can just have you come right up to the podium there. Thanks. All right, we're on the record now in Harding versus Duchesne. This is case number 2319347. Record should reflect Ms. Harding's present here in the courtroom today. We have Mr. Duchesne present by video from Otsego County Jail. And Ms. Harding, this is your motion to terminate personal protection order, is that correct? And I did have a chance to review the letter that you provided with that motion. And I just have a couple of questions for you, and I ask everybody who has obtained a personal protection order and then wants to have it dropped, ask everybody these questions, because my concern in those circumstances is that the person is asking to have the order terminated because they feel bad about the effect that it's had on the other person, it's caused some kind of inconvenience or difficulty, or they're being pressured into it either by friends, family, or directly by the other person. And I want to make sure that you're not asking to have this terminated for any of those reasons, and that it's because you really don't think that you need this. So can you speak to that?
Absolutely not. I definitely think that we no longer need this at all.
Okay, can you tell me just briefly why you don't think it needs to be in place?
So there was a lot of confusion in the beginning when I originally got the personal protection order. I thought, my understanding was that because I didn't turn in the final paperwork back to the courts saying that it was ever served or anything like that, I honestly thought that it never went into effect. However, what the PPO initially was needed for stopped as soon. So I had the PPO given to Sean by his niece. And at the time, our arguing and fighting was a lot. So I just wanted it to stop. So as soon as she gave him the paperwork, it stopped. But then I didn't turn in my paperwork at the end stating that I had him served or any of that. So I never thought it went into effect. So we didn't speak for almost 5 months, five to 6 months. And then I had heard that Sean was working on himself and had quit drinking. And in the meantime, I was working on myself because I was quite depressed not having him in my life. And I reached out to him in February with the understanding that I did not think it was in effect.
Okay.
Since February, Sean and I have been doing amazing. Like, we're talking, we're trying to understand each other, and arguments aren't happening. And then he was arrested on a child's court warrant. And I went to the jail 4 or 5 different visits. And because I was allowed to go into the jail, I thought for sure, no, that didn't exist anymore because I was allowed to go to the jail. And then I didn't hear from him on the 22nd of May. So I called his attorney and I said, hey, is everything okay? Haven't heard from Sean today. I'm worried. And the attorney advised me that Sean had been served while there in the jail, this personal protection order.
Okay.
So I immediately freaked out, like, oh no, oh my gosh, I have to fix this because now this is hindering our success and our future together.
Okay. All right. So based on what you told me, I do find that it would be appropriate to terminate the order. In any case, it would only be in effect for about 2 more months anyway. So the court will grant the motion to terminate the order. The only thing I would say, starting going forward is personal protection orders are something that the court obviously takes very seriously. And when you apply for one and get one, it creates some responsibility on your part to follow through and understand what that means. Because the court's doing its part to try and protect you, and you really want that protection, then you need to follow through with those kind of things. So to the extent that this happens in the future, it's important that you not just kind of assume it's not there anymore. And
absolutely,
it's really, you've been having Mr. DeShane violate this order over and over again, and he could have faced some serious penalties for that.
I am very much aware, and I am extremely apologetic for that. I do not want him in danger of anything because of me.
Okay, so I've signed that order. It is terminated as of today. Mr. DeShane, did you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for today.
Thank you, sir.
Okay, we've we've got to shift gears a little bit here and switch to our Crawford County docket. Mr. Butts, are you able to hear me okay?
Yes, sir.
Okay. I see we've got Mr. McFarland here, and we have, okay, let's go on the record. This is People versus William Franklin Butts. This is Crawford case 204727 and 214739. The record should reflect that Mr. Butts is present today by video from the Crawford County Jail. We have Mr. Trush here on behalf of Mr. Butts for purposes of arraignment today, and Mr. McFalda here on behalf of probation and parole. Mr. Butts, you're here for arraignment today on some alleged probation violations in both of these files. Do you understand why you're before the court today?
Yes, sir.
Okay. And have you been made aware of what the alleged violations are?
Yes, sir.
Okay. Mr. Trush, have you had an opportunity to speak with Mr. Butts prior to this hearing today?
So, yes, Your Honor. Just to give the court some background, I think the violation is on the basis of new charges that come from Otsego County. I have been appointed to represent him on those Otsego matters.
Okay. Has he requested court-appointed counsel as to the violation?
Yes, we are going to be requesting appointment of counsel.
Okay. All right. Have you had an opportunity to go through with him his rights regarding the hearing and the maximum possible penalties if he's found guilty of either the non-technical or the technical violations?
So I have not had an opportunity to do that since I didn't get the formal violation paperwork ahead of this hearing.
Okay. Mr. McFaldo, in terms of the technical violations, I don't know the status of Mr. Butt's probation. What would be the penalties if he's found guilty of the technical ones here? Has he had any previous?
Sorry, Judge. On file 204727, he's on for possession of meth. So that's a 10-year maximum. And then on 214739, he's on for possession of a controlled substance, which is a 4-year max, Judge.
Okay, and in terms of the technical violations, has he had any priors, or what would be the penalties based on his status on the technical ones?
I think it would just be 15 days, Judge.
15 days, okay. All right, so Mr. Butts, as we've just been discussing, if you're found guilty of either of the technical probation violations, and that is the ones involving consuming alcohol, the maximum penalty you can face on that would be 15 days in jail. Do you understand that?
Yes, sir.
Okay, and then as to the non-technical violations, those could subject you to the maximum possible penalties on your underlying charges, which in file 4739 is up to 4 years and 4727 is up to 10 years. Do you understand that?
Yes, sir.
You also have the right to have hearings as to both files as to whether or not you did violate your probation in any of the ways alleged. And if you wanted to have hearings on that, the court would be required to hold those hearings within 14 days if you're not released on bond. Do you understand that?
Yes, sir.
Okay. Mr. Trush, have you had a chance to talk to Mr. Butts about how he wants to plead today?
Yes, Your Honor, we would be asking that they be set for hearings.
Okay, so the court will enter not guilty pleas on behalf of Mr. Butts with regard to all the alleged violations in both files. The court will set this matter for hearing. Mr. Trush, did you want to waive the 14-day requirement, or are you asking to have the court set these within 14 days?
Your Honor, I'd like to address bond to the court before we make that determination if I could.
Okay, Mr. McFalda, do you have any recommendations regarding bond?
Judge, I do. I just like to point out, Judge, that, you know, he is facing a serious felony charge in Otsego County, which is the basis of this violations. He's been on probation a while now. He actually was straddled on his 20 file and his 0 to 17 on his 21 file. I I do think a cash surety bond on each file is appropriate, Judge.
Thank you, Your Honor. I guess what I would emphasize in regards to this, I represent him in the underlying case in Otsego. It appears that that's going to be headed for a trial at this point. Obviously, we're still early in it. We're set for a probable cause conference in front of Judge Cooper on July 11th. It's anticipated we're going to be setting an exam date at that time. Obviously, these are allegations at this point. He maintains his innocence to them. To his credit, I would say, when I spoke with him, he was aware that there was a warrant out. He had indicated to me he was making arrangements to take care of that. Anticipated that he would be turning himself in on Thursday or Friday. My understanding is that while he was voluntarily meeting with an officer in regards to the other matter, that they saw the warrant and arrested him. But I don't think there's anything to suggest that he wasn't taking it seriously or trying to avoid anything. I think that he fully intends to defend himself. Would suggest to the court that if the court feels the necessity to put a cash surety bond in place, that it be a minimal amount so that he can post that and defend these matters. Thank you.
All right, looking at both the files here, the underlying charges both of them involve controlled substances. The court notes that one of the alleged violations is that Mr. Butts was consuming alcohol in violation of his probation. The court also notes that the underlying violations involve assaultive conduct, and the court further notes that there are substantial potential criminal penalties resulting from a violation if Mr. Butts is eventually found guilty. So for those reasons, the court finds that cash or surety bond would be appropriate in amount of $10,000 as to each file. So the court will set bond at $10,000 cash or surety in each file. Again, the court finds that's necessary for protection of the public as well as to ensure Mr. Butts' appearance in any future hearings. The court will then, Mr. Trush, as to the 14-day requirement if Mr. Butts is not able to post that bond.
We would ask that the matter be set within the 14 days.
Okay, so the court will set this for hearing within the next 14 days. Ms. Koch, I know you were brought in a little bit late there. I apologize for that. I didn't see you in the waiting room immediately. So did you have any questions about where we're at so far? Mr. Butts has pled not guilty and he's requesting a hearing within the next 14 days.
No, Your Honor, and Ms. Medler is here in my office as well. Judge, okay. My question is did he request an attorney? Is he waiving an attorney?
Mr. Trush has been appointed to his other files in Otsego County, and so I think we're anticipating, and correct me if I'm wrong, Mr. Trush, that he'll be appointed to represent Mr. Butts as to these violations as well.
That is correct.
Okay, thank you.
Your Honor, before we go off the record on this, I did see Mr. Butts raise his hand in the jail. I don't know if there was something he needed to address to the court.
Sorry, I did not see that, Mr. Butts. What?
I was just curious. I didn't understand the bond situation, sir.
Yep, the court's setting bond. Go ahead.
I have full employment at A&O. I just got my daughter full time. I don't know how much. I can't come up with $10,000. Is there any way of maybe lowering it a little bit, Your Honor? I have no violations. I turned myself in. I'm doing everything. I've talked to Mr. Trush and Mr. McFalda, told him I'm turning myself in, left messages on both phones, talked to both Richard and Mike. I didn't understand the bond thing is all, Your Honor.
Yeah, so Mr. Trush, I mean, if you want to file a motion where you can lay out some of those factors a little more clearly for the court, I would reconsider the bond to the extent that you can provide some more detailed information about the circumstances, including what the current bond is on the Otsego County cases. So obviously, the court's willing to reconsider bond upon more information.
Okay.
So, okay, all right, that's all for today. The court, all parties on this file are free to disconnect.
So how much is my box? All right, thank you.
Your Honor, would you like that back over here?
Sorry, what's that?
Would you like that moved back over here?
Yes, please.
Good job. Sorry.
Mr. Smith, are you able to hear me okay?
I am. I was having a little difficulty on my desktop, so I'm streaming in by the phone.
Okay, sounds good. All right, we're on the record now in, let's see. This Lansing area Federal Credit Union?
Lansing Automakers, Federal Credit Union, LAFCO.
Gotcha, okay, versus Debbie Hughes. This is file number 2319369. And this was set for a debtor exam today. It looks like Ms. Hughes was served with the notice of the date and time of today's hearing back on May 9th. It looks like there was personal service. And this was set for 11:45. It's now 11:52. I don't see Ms. Hughes joining us by Zoom. Have you had any kind of contact with her, Mr. Smith, at all?
I have not, Your Honor. And I just double checked the file, and we keep track of all communication, phone notes, emails, and there has been no contact whatsoever in the last 6 months, which is as far back as.
Sure. Did you want to try and set this for another exam hearing, or how do you want to proceed today?
Well, I know some counties I'm in, like over in Eaton, if they fail to appear after personal service on a subpoena, they'll go straight to bench warrant. But the majority of counties that I'm in typically would like us to file motion to show cause. We'll do 9-day mailing to the address of the personal service, which we confirmed through our skip trace databases. So we'd like to file a motion to show cause. If she fails to appear at that time, we'll ask for a warrant.
Okay, I think that's an appropriate way to proceed. So I'll just ask that you do that. Once I receive that, I'll sign it, and we'll go from there. Anything else that you wanted to state for the record today?
Nothing for the record. Appreciate the help. Thank you, Your Honor.
Okay, thank you. You're free to disconnect.
Perfect.
That also concludes the court's morning.